think Mr. Trapp and Diane telling me, just a moment before I get there, I did want to make one statement to all the attorneys that are present here. I'm entering an order, sui sponte, on motion today, reiterating the requirements of Rule 9.01 about pretrial publicity. I know you attorneys know exactly what that rule specifies. This court order quotes it verbatim, but I expect the attorneys and their clients to obey this requirement about dissemination of certain information about public communication that relates to this case. I intend for this case, if we have a trial and when we have a trial, can be tried in this courtroom and not in the clerk ledger or on the local news. If any of you have any questions, the clerk will have a copy of this order. It just reiterates the requirements of the law, Rule 9.01. That being said, since we have a witness here, Mr. Trapp, that you've been hired to represent, that wants to be excused, do you want to address the court on that matter and then we get counsel an opportunity to respond?
Yes, Your Honor. We have filed a motion to quash the subpoenas served on Case Steiner, staff attorney for Judge Will. There are really three basic reasons.
Can we get to the podium, please?
Yes, Your Honor. Your Honor, I'm making a limited appearance on her behalf in her capacity as staff attorney for Judge Will. She is not a party. It's not involved in this dispute between the district attorney's office and the attorney general's office. I will say as an aside, Your Honor, in order to get into the electronic filing system in the clerk's office, you have to treat yourself as a party. We did that to facilitate the electronic filing and transmission of that filing, and we would intend to remove her as soon as possible from that, but she is not a party. The first reason it should be quashed is just a technical reason. They didn't put a time of appearance on it, put a date on the subpoena, and more importantly, there was not any witness fee provided to her, which is required in Rule 45, which is the controlling rule, civil rules procedure controlling rule under Uniform Rule 2.01. Secondly, Your Honor, her testimony would not be relevant in any fashion to Mr. Smith's amended motion to quash and dismiss the indictment. Your Honor, since we're arguing the motion, I have Mr. Steiner come up for that purpose. I didn't write the rule on that. If the court were to look at the motion to quash, there is an argument made about the Attorney General's office having some personal interest in this. And there are two multiple items listed, and two of those involve to some extent Judge Will. One of them deals with a transcript of a hearing which has been unsealed and has been mooted.
Yeah, since you mentioned that, let me make sure I understand. The Supreme Court this past Friday ordered the unsealing of the transcripts, I think, of the two hearings that have been, for lack of a better word, unclear as to whether we're authorized with the clerk legislative motion to unseal. That issue, I assume, is resolved itself. That is the transcript of the two hearings. Now the parties have access to that.
Your Honor, last Friday they ordered that 120 unsealed, and we got it. I got it last Friday.
And that 120 was a hearing on?
That was a hearing where they go into these allegations her purposes, I don't think it's an issue. I do it as well.
Is that the one having to do with the subpoena for Stanford not? Is that his name? Or is that a...
It was a June 21st year.
There were two hearings. One was in March, I think, maybe, the other in June.
Yes, we had the one from Washington State.
Okay. Do you have the one from June?
I don't believe it was right.
Well, what's the Attorney General? I don't think you have any objection to that. I intend to order, if necessary, the court reporter for Judge Will to transcribe and make those available to both sides in this case.
We have no objection. There actually one other matter. We had understood that the hearing before Special Master Amy Whitten had been transcribed. That's in one of the cases the court's already moved on. But we don't have the transcript of that proceeding yet either. I required a court reporter, and she referred me to Mr. Wallace. Mr. Wallace, and then he referred me back to the court reporter.
Is that the hearing where the Magistrate Amy Whitten recommended that the subpoenas go forward on some of the witnesses, but
not on Judge Will.
yes, denied it on Judge Will? Is there an issue? I'm sorry, Mr. Frank.
John, I had one name quick hearing. I had per counsel.
There's only one Amy Whitten hearing, I think, from what I've read.
We don't have that.
Okay. You have that, can you furnish that?
Yes, sir.
Okay. Well, if that's an issue, I want to make sure this other hearing, the June hearing, that Mr. Wade, you say you do not have a transcript of, but you get that you get that. I intend to order that you would have that available to you. So anyway, I didn't mean to interrupt Mr. Trapp, but I wanted to just make sure. I thought those issues had evaporated, for lack of a better word.
We had, the state had no objection to any of those matters now.
Okay.
I see everybody had action.
And from Judge Will's email, I thought he, in effect, said he didn't have any objection. He just wanted a clarification that that was the intent of the court, and I intended to remove that ambiguity if it is an ambiguity. All right, Mr. Trapp, you may proceed.
Your Honor, that part is moot as far as Judge Will would be concerned, or certainly Grace Steiner. The only other part of the motion to quash that relates to Judge Will at all would be found on page 7. This is a docket number 16, Your Honor, of the amended motion to quash and dismiss, subpart G, as in George. And it says that as an agent of the state, Judge Will intentionally violated Smith's due process rights by that order temporarily disqualifying him from appearing before the grand jury. That was then appealed by a writ of prohibition and mandamus to the Mississippi Supreme Court. And this is the argument they're making to you, that they say that she would be a witness on. Knowing that this order, talking about Judge Will's order, that they violated Smith's due process rights, the Attorney General nevertheless decided Judge Will's lawless action before the Mississippi Supreme Court supported the lawless action before the Mississippi Supreme Court, or defended, I should say. And then reading on, still in that same section, the Attorney General defended Judge Will's unconstitutional acts. Both of those go to what the Attorney General's office knew, not what was motivating Judge Will. So it's not testimony that would be relevant. There's no showing how Case Steiner would know what was motivating the Attorney General's office. And then we get to the most significant and important reason this motion must be, the quash must be granted. And that is what we now heard in a broadening fishing expedition is that Mr. Wade says, try to write it down, it's inconceivable that Judge Will's opinion, written on June the 23rd, which he now described as a well-written, well-reasoned, not what he was telling the Supreme Court when he was mandating Judge Will, Your Honor. He's the well-reasoned. There's no way their office could have done that. And what is that? That's nothing but speculation and trying to argue by any window. And he is asking this court to breach the confidentiality, deliberation, mental process privilege that all judges enjoy, particularly with their staff, in order to satisfy some speculation or fishing they've done that he doesn't even mention in this motion to dismiss. So that's all it is. And when he wanted to serve a subpoena on Judge Will and found out he was going to be out of town, and Ms. Steiner, then he subpoenaed Ms. Steiner. Your Honor, there is no basis for him to delve in and violate the privilege that Ms. Steiner has and Judge Will's staff have, and that every judge's law clerk and every judge's staff has with his own separate judge. It would be improper and it's unprecedented and would be totally uncalled for in this instance. Think about, Your Honor mentioned the Berry case in discussing earlier. Think about if I'm the defendant in the Berry case and I see Your Honor dissenting and saying my indictment should have stood, I want to take your law clerk's deposition because I think there must be something going on between you and the prosecutor. I mean, that's how ridiculous this is, and it's also more than ridiculous. It strikes at the very heart of the judicial process, the judicial deliberation. Judges have to be able to talk to their law clerks and staff members concerning decisions that they have to make. So I've never been a judge, but I can't imagine it's a lot different than sitting down and talking with an associate. What do we do here? What do you think of this? What do you think of that? And then you have to make a decision. The law is just crystal clear. You don't look behind the decision. The judge speaks through written decisions and orders issued in public and in the court. And you don't enable a party who disagrees with it to go behind it and go fishing. And you don't look at the reason or try to examine the reason that a judge makes the decision he makes. It's either he believes in that decision and it's upheld, he believes in that decision and it's not upheld. And the Berry case is a fine example of how the rule of law works in our judicial system. Ruling made in the lower court, middle level courts agree with it. One judge disagrees, Mississippi Supreme Court disagrees, and dissent in the Berry case. And that's, every case is like that, and that's the way it has to work. This subpoena must be quashed because it is invasive of a fundamental and dear cherished privilege that exists between every judge and his staff. And it would be the same even if Judge Will here and not the staff. But think of this. Now you're bringing in a staff leader person and you want to question the motivation and reason for the judge's opinion. And think how that hits that staff member and how it discourages open discussion, just like the attorney-client privilege is enjoyed by Mr. Smith and Mr. Wade, and we can't look behind that and start questioning motivations. So also, and even more so, I say, is that privilege of confidentiality that exists between a court and his or her staff. And for those reasons, Your Honor, this subpoena must be quashed.
Wait.
I couldn't agree more with what counsel said about communication between the law clerk and the judge. I absolutely agree 100% with what he's talking about. But that is not the purpose of this subpoena. Here is our concern. On June 22nd, the Attorney General calls Mr. Smith to be arrested. According to an affidavit that's been filed by Mr. McBride, that came immediately after Mr. McBride had been called by two assistant attorney generals inquiring about whether they were found to be the subject of a grand jury investigation. On June 23rd, and I didn't tell the Mississippi Supreme Court anything different, Judge Will writes, and Your Honor has seen the opinion, I'm sure, it's an obvious denial of due process that the Supreme Court had because Mr. Smith had never been consulted.
Well, you understand, the Supreme Court reversed Judge Will not on the substance of what he did. They reversed him on a procedural issue of due process of not giving your client an opportunity to be heard before that order was entered. It didn't have anything to do with the merits of the order, it had to do with the due process of it. Well, go ahead.
Exactly right. I would point, Your Honor, he says this is speculation. You know, I write briefs all the time, and I understand Judge Wells is a very skilled writer, and I can see that he is. It is very difficult for me to believe that on June 23rd, Judge Wells wrote that opinion without input from the Attorney General that he was about to be arrested. In other words, that the Attorney General was personally involved in this case and getting that opinion written. And that was I believe, that's why I'm calling to ask her. I want to ask her because she may say absolutely not. We wrote that opinion, never heard a word from the Attorney General. We saw it at Jim Lewis' news conference, and then we wrote it. But I think we're entitled to ask her whether the Attorney General was so involved in this case that he had ex parte communication with the judge and had Mr. Smith removed from office the very next day, relying on what did on this arrest. And I feel like we're entitled to ask that. We don't have to ask, and don't intend to ask her anything about her communications with Judge Will, about how the opinion was prepared, except to say, is it not true that the Attorney General had told you in advance that he was going to arrest Mr. Smith, and then reliance on that y'all drafted the opinion and had it ready for when the arrest came about? If so, that shows the Attorney General is intimately involved in this case, is personally interested in it, and should not be acting as Attorney General.
That was my next question. How does that relate to the charge against your client? Two counts of conspiracy and one of a misdemeanor, other than as it may relate to my removing the Attorney General and appointing an independent prosecutor.
Yes, that's what it relates to. As part of our motion, we give a number of reasons as to why the Attorney General is not impartial, and that is one. If the Attorney General goes to the judge and gets the judge to enter an order without due process, agrees with the judge, tells the judge, I'm about to arrest Mr. Smith, and the judge then drafts an order which denies Mr. Smith his order without due process, then the Attorney General has been involved in that. And I haven't talked to this lady, Your Honor, so I don't know whether that's the case or not, except to say, I write briefs all the time, and I certainly couldn't write a brief of that quality and go into this arrest in one day's period. I don't even know what time it is. But I'd like to ask her if she says yes, Judge Wells, and we're just wordsmiths, and we did this when we saw the rest of it.
Well, Mr. Wade, there's a lot of events that occurred before June 22nd in the presence of Judge Will.
Yes, that's right.
Motions to null cross,
That's right.
adversarial hearings.
Absolutely.
Witnesses been subpoenaed before the grand jury coming in and asking that the subpoenas be quashed. There's a lot of reasons that Judge Will may have been motivated to be doing something like what he did when he did it. Your suspicion is the time.
My suspicion is the time, and I don't want to just, counsel says it's speculative, I agree that it is. And we have somebody here who apparently knows, which is lawful, and I'd like to be able to ask her. If she says no, we based all this on all these sealed hearings we had, and once we saw the press conference, then we did the order. That may be what she says. It's hard for me to believe, and I write briefs all the time, notwithstanding the fact that they did have all this sealed hearings. Mr. Smith wanted me to point out there's a lot of evidence. There's been discussions about Mr. Smith and his absence, but that's not really the point of this.
What I understand you saying, you called Ms. Steiner up here examiner, the sole area of inquiry that you intend to ask her about is request for input that the Attorney General's office may or may not have made Judge Will to enter this ex parte order banning him from appearing before the grand jury.
Yes, sir, that's it.
That's it, the sole purpose.
Yes, sir.
What's the Attorney General say to that? And Mr. Trapp, you too, I want to hear from you.
It's just what Mr. Trapp said, right, the fishing expedition. We don't have people who report to the judges and ask them to write sua sponte orders. That was the judges doing. We didn't urge that. We didn't have any communications with the judge's office before that order was entered. It came as a surprise to us, just as it did Mr. Smith.
Mr. Trapp, if Mr. Wade's presentation here, he's not going to ask the law clerk anything about the legal opinions or legal assistance that the clerk gave to the judge. He's solely desiring to ask what input the Attorney General's office had immediately prior to Judge Will entering that order. What's your response to that argument?
My response is that's privilege, and I would not allow her to answer that question. He's not entitled to go into the motivation of Judge Will in connection with that order. The order came out, he attacked it in the appropriate fashion, perhaps for procedural, and the court ruled. It's part of the privilege, and it's not anything that he should be allowed to ask her or Judge Will. And it would be our intention to respectfully decline and any kind of question like that. And it is pure speculation. He says, I find it difficult to believe. I find it inconceivable. Well, gee, I write briefs. First, it's sort of the meaning. And underlying all this is the meaning on Judge Will and Ms. Steiner to think they're incapable. And the next question is, well, what did you know? Why did you put this in that order? Why was that in that order? Your Honor, all of those things, this is totally off base, and it's improper. We object to it on the basis of privilege and for the other reasons that I said. Clear, and I think there are other people he can go to for that information. For example, the Attorney General's office. He should not be breaching the privilege, and he should not be putting a law clerk in that kind of position.
May I respond to that?
Very, very briefly.
That's really concerning if he's saying that the Attorney General is representing Judge Will, and that would mean that the Attorney General is representing the presiding judge in the prosecution against Mr. Butler, for example. So for him to be saying, well, the Attorney General is my lawyer, and he's the adverse party in this case, the Attorney General is the adverse party, and he's telling us, well, it's privilege, the Attorney General. I mean, that's, now he's apparently claiming the Attorney General is his client, which really raises serious due process concerns. We have the Attorney General being the client of the judge. But the court had to rule on what's privilege.
Well, this way, this is a very difficult area of the law, in that the Attorney General's office supposedly is available to represent statewide elected officials. I can't help but mention a couple of times in my career where I personally was sued for millions of dollars as a judge that entered orders in particular cases and picked up the phone and called the Attorney General's office because of their legal obligation to provide me a defense.
Yes.
I don't know if later on when the Attorney General is prosecuting in my courtroom, let's say a felony charge of abuse of a vulnerable adult, which they did prosecute from time to time, whether I would somehow be automatically disqualified because they were representing me in federal court in a pending civil suit where I had been sued as along with a bunch of other judges for millions of dollars. I don't know how to respond to what you just said, other than it's a very difficult area to be involved in. The Attorney General does have a statutory responsibility to defend at request statewide elected public officials.
I understand. Your Honor, I was going to say this particular area, if the Attorney General is requesting some action against Mr. Smith ex parte, then I don't see how that's legal advice that he's giving to Mr. Will. He's not acting as a client, he's acting as an advocate before the judge at that point.
Okay. All right. Mr. Travis brought a motion to quash a subpoena issued on Kate Stanger, who is a law clerk for Judge Will. From reading the motion and to quash the subpoena, it's my judgment that it's well taken. I think it borders on absolutely privileged communication between the judge and your own staff attorney or law clerk. I can't now conclude that there's any stronger privilege under the law other than those that protect the judicial process, regardless of who the judge may be or the situation, the communications and motivation of a judge to enter an order and attempting to find out those motivations by subpoenaing the law clerk, I think, breaches the privilege that exists in that respect. So I'm going to grant your motion to suppress and release Ms. Steiner from the subpoena.
Thank you, Mayor. We'll make prepare an order now.
Would you please? Yes. Mr. Davis, I promised you an opportunity to be heard, and I want to live up to my promise.
Yeah, before he began, MBN witnesses were here, and I think they were here solely on the motion to quash. I spoke with Mr. Wade, he said he wanted to put something in the record that they might be excused.
Guys, do you mind just a minute if we got people here under compulsion of subpoena that may not need to remain here?
I'm sorry. Oh, yeah, John, we suspended the MBA. What we want to make is a record, I agree that they can leave. The parties stipulate that the MBN refuses to disclose the name of the confidential informant in the Butler search.
All right, now, let me back up. Having read that transcript, that you're talking about an individual, is it the first arrest or second?
It's the first arrest.
The first arrest that is supposedly the confidential informant that undergirded the search warrant, and anyway, that was a basis of the search warrant the first time.
I told counsel that was a point in having the MBN agent here that they will not disclose the name of the confidential informant. And that's on the stipulation. He's free to go if they stipulate that, and I can argue later the relevance of that.
So stipulate. Mr. Baker, okay, let the record so show. All right, that witness can be excused. Any other witnesses in a similar situation that are still waiting?
Not that I'm aware of.
Okay.
John, I was going to ask the court, we have some matters that don't require proof, as well as others that don't require proof. I was going to ask maybe if the court would consider that and start with those before moving to start witnesses.
That'd be fine. I want to hear from Mr. Banks sooner or later, Mr. Banks. Better sooner than later.
Thank you, Your Honor. I think that you probably bursted my bubble pretty good. I had about a 19-page argument to make to the court regarding the Washington indictment on behalf of Jimmy McBride, which all of a sudden has been reduced to one page, so I won't be here too long.
Okay.
As you are aware, Jamie McBride is an assistant district attorney. He is not the attorney, district attorney. And as such, he acts at the will of the DA. And when the DA instructs him to do something, he's obligated by virtue of his employment to do so, unless that which he is being asked to do is in fact unlawful. The prosecution has presented us thus far over 230 pages of discovery, which include transcripts, affidavits, things of that nature. Within those 235 pages, there are only 3 distinct naming of Jamie McBride. One was that he had to prepare an affidavit relating to a conversation that he had over the telephone with the 2 assistant DAs. AGs, excuse me. The other was an inquiry as to where they were with the Butler case. That, however, was hearsay testimony. None of the documents or discovery presented at anything that Jamie McBride said or anything that he did that was not hearsay. The other was so minuscule that it's not even worth mentioning. Which brings me to the fact that the motion to quash is based a lot and primarily on Rule 706 relating to essential facts. There's been no evidence at this point. Discovery has been provided to us that anything that Jamie McBride was supposed to have done on behalf of the DA and the DA's instructions is unlawful. It's not unlawful to prepare an affidavit. It's not unlawful to develop a timeline dealing with videotapes that were involved in this case as far as the Butler case is concerned. Particularly when that particular item was requested to be provided by Judge Wheel from DA Robert Smith. And DA Robert Smith said, here, you do the timetable as it relates to the film or the tapes that took place and was confiscated and or destroyed from the house which Butler had either possession or part possession of. I've got to ask and to point out that the indictment contains no specific elements in which McBride committed a crime. Why was he even named in this indictment is beyond me. Except that he's gotten caught up into a power play or a disagreement or whatever you want to call it that's affected this entire judicial system in Hinds County and involves the chief law enforcement officer for the state of Mississippi as the AG and the district attorney of the largest county in the state. And I agree that that should not be happening and it's hurting our system and our image and things of that nature, but it's hurting Jamie McBride to have to defend something when the essential elements of that indictment are not there for him to know what he is supposed to defend. The indictment states, not a specific date, but it states December the 15th of 2015 to June 22, 2016. As the assistant district attorney, Jamie talks with the district attorney virtually every day about the activities of the office. Jamie McBride wasn't in charge of the Butler case. He wasn't prosecuting the Butler case. He was never participating in any of the hearings that the court is aware of that have taken place both secret and otherwise. No participation whatsoever but those 3 things that I said that he was named as doing is contained in the discovery that we received. How did...
Mr. Daniels, let me stop you just a minute.
Yes, sir.
You are aware, I assume, that the sufficiency of the evidence that was presented to the grand jury to justify the returning of an indictment is not a matter that I can consider. We don't have summary judgments for Rule 56 in a criminal case. Once the grand jury officially returns an indictment, that in and of itself is probable cause sufficient to go to trial. I think what I hear you saying is, as far as you're concerned, against your client that might justify a jury returning a guilty verdict, or for that matter, a judge denying a motion for a directed verdict at the close of the state's case. But my concern is, we had a case in the Court of Appeals where a circuit judge, in effect, granted a summary judgment motion in a criminal case because he didn't see any evidence where the government could convict the defendant, and he just short-circuited it all and dismissed the indictment, and obviously it got reversed when the state appealed the judge's ruling. But is that not what you're arguing to me? Is that your client is caught up in a web of power struggle here and is being used as a pawn, so to speak, and is being twisted around, and I assume in your belief that he might somehow capitulate and begin to help the Attorney General's office make a case against Mr. Smith. I assume that's what you're thinking.
I don't think he's going to capitulate when he has no knowledge whatsoever as to what the subject matter is that we're here for today as it relates to the charges.
Right, I understand that.
And he has none, but he is a servant to an employer who has directed him to do what I mentioned that he was required to do, the affidavit, the timeline on the tapes, and then one other reference which was not a document. And now he's having to be publicly indicted, publicly accused of committing a crime, when the essential facts regarding this particular crime, and we agree with the prosecution's position that they don't have to give the elements of the crime of hindering prosecution in itself, but it does require, due to the time period of 6 months as to when it occurred, and it does need to provide some specific fact of what the nature of what occurred that constituted conspiracy, what came about. I can't defend this man in the posture that the court that they put me in now, with this being motion to quash being overruled. I've got to go back and sit down with Mr. McBride and go with him day by day by day. Do you keep a diary? Did you keep a record of everything that you met with Mr. Smith about that would even come close to committing an unlawful act? I can't do that. My hands are tied. And it goes back to, how did he conspire to commit the crime of hindering prosecution by preparing that memorandum which I mentioned? When he was instructed, that particular memorandum was instructed by Judge Wheat. If I've got all the discovery that I'm entitled to get, if I know all the facts that the prosecution is required to provide to me to defend Mr. McBride, then I'm totally convinced, directed verdict or otherwise, that this man ought to walk. But to make him have to endure what he is having to endure with his family and other family and friends on this flimsy bit of what's been provided so far is in itself an injustice. And I hope I didn't get too loud, but I feel very strongly about this case. And we also would request that, and I'm sure the court will, but just for the matter of record, that you have two, first and second motion to quash, and we incorporate in everybody's arguments those two motions.
All right. Thank you, sir. Attorney General response.
As the court pointed out, Your Honor, you've already ruled on the first two counts. Just to reiterate, Mr. McBride is not charged with hindering prosecution. He's charged with conspiracy to hinder prosecution. Mr. Dax pointed out that Mr. McBride was working at the will of the DA. And I'd like to point out to the court that, Your Honor, the DA cannot instruct someone else to violate the law. And if that person decides to follow the DA's request to violate the law, he gets to be standing accountable to that. And as the court did point out as well, most of what Mr. Dax argued is on the grounds of sufficiency of evidence is a question for the jury to decide, should this matter go to trial. And as to the issue of the hearsay statements, it's the state's position that the statements Mr. Banks was referring to would be admissible under 801-2E, which reads, the statement is offered against an opposing party and was made by the party's co-conspirators during and in furtherance of the conspiracy. And that's the state's position to all the statements that reference Mr. McBride's activities in the conspiracy. That's all I have.
Other than these affidavits, I remember one statement in the videotapes where Mr. Johnson infers, if not directly, indirectly, that Mr. McBride is working on getting Butler free, or something to that effect.
Yes, sir.
Did I misread that in the tapes?
No, you're
Okay. Okay.
That's all I have.
All right. Anything else, Mr. Chairman?
I believe it was the DA that made that statement, Your Honor, as to whether or not, well, to get Mr. Butler free. That was not Mr. McBride.
Yeah, that was Ivan Johnson's statement, is that what you're saying?
Yes, sir. Either his statement or a conversation between Mr. Johnson and Mr. Smith.
Well, the inference from the entire content of the discussion seemed to be that Mr. McBride was working on whatever he was working on to try to get Mr. Butler free. Well, at least it could be argued to a jury that's what they were talking about, I assume. All right, thank you, sir. All right, I think consistent with my prior ruling, I'm going to deny the motion to quash the indictment as to Mr. McBride on counts 1 and 2. I don't want to say more than I need to say, but I think it's legally sufficient. The law